Okay, so we're back with video number 3. This video is going to tackle the defenses to assault and battery. In the previous two videos, we were taught about what is assault and what is battery. And now we're going to discuss really quickly the defenses to assault and battery. So we're going to go through consent, self-defense, provocation, contributory negligence, extirpi causa, necessity, parental, statutory, and other lawful authority. And then once we're done all of those defenses, we're going to quickly run through the assessment of damages for assault and battery. And I have to let you guys know every single time to don't forget to subscribe, like, share, and of course, drop your comments down below. Let us know what videos you like to see in the future. Ask any questions you may ask so that we can interact with you guys, of course. Okay, so on to the introduction. Um, it is possible to identify at least 8 defenses which might be raised in an action for assault and battery. These are consent, self-defense, parental authority, statutory authority, extirpi causa, necessity, contributory negligence, and provocation. So we're going to start with consent. Consent is not a defense in the strict sense of the word. Where the plaintiff consents to what would otherwise amount to an assault or battery by the defendant, the latter will have a complete defense. Therefore, the plaintiff ought to establish as part of her claim that she did not consent to the trespass. Consent may be expressed or implied from the circumstances. Therefore, for example, a participant in a boxing or wrestling match cannot recover damages from his opponent for blows inflicted upon him during the fight, for he will be taken to have consented to them. Another example of consent is where a patient enters a hospital for a surgical operation or a dentist's surgery for a dental treatment. Such a patient cannot sue for battery or false imprisonment in respect of any of the force applied to him during the treatment or any confinement under an anesthesia or otherwise. In the case of Kobe versus Smith, the parties were players in an amateur game of rugby. The defendant struck the plaintiff on the jaw with his elbow, fracturing it in 3 places and causing extensive dental damage. The plaintiff sued for battery and the defendant pleaded consent. That is, that the plaintiff had assumed the risk of injury inherent in the game. It was held that the defendant was liable. Justice Opal said, "It cannot be said that because the plaintiff played rugby that he consented to the type of conduct and actions exhibited by the defendant. By playing a sport which involves physical contact, a player does not assume any and all risk. There must be a realistic limit as to that risk. Similarly, a person who engages in a sport in which violence and injuries prevail is not rendered immune from legal liability. It is agreed that a player's conduct in a game involving physical contact should not be judged by standards suited to polite social intercourse. Consent must be freely given. In other words, consent must be freely given, otherwise, it is ineffective. Consent effected by duress or undue influence is therefore invalid. Where it is brought about by fraud, consent will not be a defense where the fraud relates to the nature of the act or its consequences. A minor may give consent if she is capable of fully understanding the consequences of the act consented to. The issue of consent often arises in the medical context. In the case of Chatterton versus Gerson, during a hernia operation, the trapping of a nerve caused the plaintiff great pain. The defendant injected the plaintiff, thereby blocking the pain but also rendering her right leg numb. She sued in trespass inter alia on the ground that she did not consent to the injection since she had not been informed of the potential consequences. It was held that the defendant was not liable in trespass. Justice Burstow said in that case that the consent must be real. Once the patient is informed in broad terms of the nature of the procedure which is intended and gives her consent, that consent is deemed to be real. It should be noted, however, that consent is limited to the doing of the act for which permission is given. So that, as Justice Burstow said in Chatterton versus Gerson, if by some accident, as in a case where a boy was admitted to a hospital for a tonsillectomy and due to administrative error, he was circumcised instead, trespass would be appropriate cause of action against the doctor. Finally, it should be noted that it may not be possible to consent to serious harm, and this was seen in the case of R versus Brown. An assault or battery is justified if committed in reasonable defense of oneself or another. What is reasonable depends on the circumstances. Two principles are clear. One, the battery must be committed in actual defense from attack and not by way of retaliation after an attack. And two, the self defense or defense of another must be reasonably commensurate with the attack. If the plaintiff threatens the defendant with a deadly weapon, the defendant may defend himself with a deadly weapon. On the other hand, if the plaintiff merely punches the defendant with his wrist, the defendant should be justified in defending himself with his fists. But he would not be justified in pulling out a gun and shooting the plaintiff, unless perhaps the plaintiff were a karate expert who was capable of using his hands as deadly weapons. In Kasher versus Nemeth, C, N, and N's wife were present at a private party. C was acting in an irritating manner by attempting to kiss N's wife against the latter's will. N struck C a karate blow to the side of the head, breaking C's jaw. It was held that N was entitled to act in defense of his wife, but that he had used excessive violence and was liable for battery. In the case of Badu versus Campbell, Justice Jamadar emphasized that the onus of proof was on the defendant to demonstrate one, that his belief that he had to act in self defense was both honest and reasonable, and two, that the action taken by him in self defense was reasonable, having regard to all the circumstances of the case, including the fact that the act of self defense was taken in the heat of the moment, and the reasonableness of the belief that a person needed to act in self defense would depend on whether that person reasonably thought that it was necessary to defend himself against attack or the risk of imminent attack. In the instant case, the evidence was that the claimant approached the defendant's place of business, a restaurant and bar, uttering obscenities and threatening to kill the defendant. The defendant drew his licensed firearm and called out to the claimant to back off, but the claimant continued to advance menacingly towards him. When the defendant realized that he could retreat no further, and having caught sight of a black-handled object on the claimant's waist, he fired a single shot from the firearm, striking and wounding the claimant in the leg. Justice Jamadar was satisfied that even if mistaken, the defendant both honestly and reasonably believed that there in fact existed a real danger to him, insofar as the plaintiff appeared armed, hostile, and intent on attacking him in order to cause him grievous bodily harm and even to kill him. Further, in my opinion, the defendant took reasonable action and used reasonable force on attacking him in order to cause him grievous bodily harm and even to kill him. Further, in my opinion, the defendant took reasonable action and used reasonable force in defending himself from his perceived imminent attack. Assault or battery is also justified if done in defense of one's own property, whether it be land or chattels, or even property which one is defending as an agent of the owner or occupier. Again, the force used must be no more than necessary. Where the battery is in defense of land, the following distinction is made. If the plaintiff enters the defendant's land forcibly, the defendant may at once use reasonable force to remove him. But if the plaintiff enters peaceably and without force, then the defendant must first request the plaintiff to leave before any force will be justified. If the plaintiff, after being requested to leave, resists these attempts to eject him, he may himself be liable for assault and battery. There is no defense of provocation so as to extinguish liability, nor will it serve to reduce damages which are compensatory in nature, although it might reduce punitive or aggravated damages. In the case of Lane versus Holloway, there were poor neighborly relations between Mr. Lane, who was 64, and Mr. Holloway, who was 23. One night, Mr. Lane called Mrs. Holloway a monkey-faced tart. Mr. Holloway remonstrated at this. Mr. Lane threw a light punch at him, But Mr. Holloway then punched Lane in the eye, opening a wound which took 19 stitches. It was held that the defendant was liable and the damages were not to be reduced by the reason of the plaintiff's provocation. Lord Dennis stated, provocation by the plaintiff can properly be used to take away any element of aggravation, but not to reduce the real damages. Lord Justice Salmon said, when considering what damages a plaintiff is entitled to as compensation for physical injury, the fact that the plaintiff may have behaved badly is irrelevant. The defendant in Lane versus Holloway also sought to rely on contributory negligence. This defense is discussed in greater detail when we do negligence. Basically, it means that the plaintiff was partly to blame for the damage caused to him and his damages should be reduced by the extent of his responsibility. Lord Justice Salmon said in the case of Lane versus Holloway that he thought it impossible to hold that what Lane did, however rude or silly, amounted to contributory negligence. In the case of Barnes versus Nair, where it was held that contributory negligence may be a defense to intentional trespass for the person, given sufficiently serious conduct on the part of the plaintiff. Okay, ex turpi causa. Extirpe causa non oritur actio is a Latin phrase meaning from a dishonorable cause an action does not arise. This is a legal doctrine which states that a plaintiff will be unable to pursue legal relief and damages if it arises in connection with their own tortious act. In the case of Murphy versus Culhane, the deceased widow sued the defendant for a fatal assault on her husband. It appears that the deceased and others had come to the place where the incident occurred with the intent of assaulting and beating the defendant. The issue was whether or not the plaintiff was entitled to judgment on the pleadings without trial, or whether, inter alia, the defenses of extirpe causa and contributory negligence applied. Lord Dennen said on the topic of extirpe causa, a man who takes part in a criminal affray may well be said to have been guilty of such a wicked act as to deprive himself of a cause of action. He, he was further prepared to allow contributory negligence since the plaintiff's conduct might well have been such as to make him liable in tort. On the topic of contributory negligence, he said, even if the plaintiff were entitled to damages, they fall to be reduced because the death of her husband might be the result partly of his own fault and partly of the default of the defendant. In the present case, the conduct of Mr. Murphy may well have been such as to make him liable in tort. All right, so the case of S versus Westbert's Health Authority. It was proposed to sterilize F, an adult with a mental capacity so to res- It was proposed to sterilize F, an adult with a mental capacity so restricted it was impossible for her to consent to the operation. It was agreed that the operation was in her best interest. The issue was whether such an operation would be an unlawful act. It was held that the operation was in F's best interest and could therefore be lawfully performed on her despite her inability to consent to it. Lord Gough said there is a third group of cases which is also properly described as founded on the principle of necessity. We are concerned here with action taken to preserve the life, health, or well being of another who is unable to consent to it. Such action is sometimes to be justified as arising from an emergency. In truth, the relevance of an emergency is that it may give rise to a necessity to act in the interest of the assisted person without first obtaining his consent. Emergency is, however, not the criterion or even a prerequisite. It is simply a frequent origin of the necessity which impels intervention. The principle is one of necessity, not of emergency. Other examples of necessity may be seizing a person and dragging her forcibly from the path of an oncoming vehicle, and where, as a result of an accident or otherwise, an adult person is unconscious and an operation cannot be delayed until he or she recovers consciousness. That was said by Lord Brandon. In the case of Lee versus Gladstone, it was held that force feeding of a hunger striker was not assault because it was necessary to preserve life. However, the force used must be reasonable in that circumstance. A parent may punish a child in a reasonable manner, including the infliction of corporal punishment, and the state may also inflict physical punishment where it is not unconstitutional to do so. At common law and under statute, a headmaster may flog a child. Mears versus the AG of Barbados. The plaintiff sued for damages when her headmaster flogged her for participation in a prank to put courage in her classroom. It was held that there was no battery by the headmaster. Justice Chase said in that case that the common law allowed those in lawful control or charge of a child to discipline it by way of corporal punishment. In Barbados, a head teacher was also authorized to administer corporal punishment by virtue of Section 18 of the Education Act. In order to be lawful, the instrument used must be a proper one, and the force used should be proper, reasonable, and moderate. Okay. Where the plaintiff is physically injured as a result of an assault and battery by the defendant, damages are assessed in the same way as in cases of physical injury caused by negligence, and the same heads of general damages such as pain and suffering, loss of amenities, loss of expectation of life, and loss of earnings apply. But apart from the damages for any physical injury, which are compensatory, the plaintiff may recover aggravated damages for injury to his feelings, that is, for any indignity, disgrace, humiliation, or mental suffering occasioned by the assault. In the case of Sudan versus Carter, a 26-year-old student was knocked unconscious by a karate black belt who was employed as a bouncer at a disco. Justice Hossein considered that the circumstances surrounding the assault warranted an award of aggravated damages. He said the plaintiff was assaulted in the presence of friends and a crowd of persons and suffered the indignity of being knocked unconscious by a bully who must have found the plaintiff an easy prey upon whom to demonstrate his martial arts skills. The second defendant's unmitigated rancor still seemed to pervade his cold blooded expression and attitude at the trial. Further, the circumstances at the entry to the disco must have been such as to create in the mind of the plaintiff a suspicion which found expression in an instantaneous accusation that racism was practiced, especially upon sight of persons of fair complexion being admitted merely by payment of the required admission fee. The result was that his dignity and pride must have been bruised. All these factors, to my mind, would attract an award of aggravated damages. Where the assault is carried out by a police officer or other government official, exemplary damages may also be awarded under the rule of Rooks versus Bernard, which established that oppressive, arbitrary or unconstitutional actions by a servant of the government may attract an award of exemplary damages, the purpose of such an award being to punish the defendant and to deter him from similar behavior in the future. In the case of Kwashi versus Airport Authority of Trinidad and Tobago, two supplementary police officers who were employed by the airport authority unlawfully seized the plaintiff, a taxi driver, and at the Crown Point Airport in Tobago. One officer held the plaintiff's arms behind his back while the other struck him repeatedly in the face. The plaintiff was then handcuffed and taken to the security charge room, where he was detained for several hours. The plaintiff was later charged with entering a protected area and resisting arrest. The charges were dismissed by the magistrate. Justice Wills awarded exemplary as well as aggravated damages for the assault and detention. He said, in this case, there can be no doubt that being beaten and or assaulting a person at a public place and an international airport, and then having him arrested and handcuffed and taken to a cell or jail where he is kept for hours without justification could be a most humiliating and traumatic experience, which must require a court to compensate him for his injured feelings. In addition thereto, Where the agency through which he has suffered such a humiliating and harrowing experience is a state or statutory body, there must also be awarded damages as a punitive measure to deter others who may be like minded. In the circumstances of this case, I hold the view that aggravated and exemplary damages ought to be awarded, since the conduct of the defendants was, to say the least, outrageous and compounded by the fabrication of the charges as justification for inflicting a severe and humiliating beating at an airport where people had been arriving and departing. In the Jamaican case of Scott versus Wilkie, however, where a lifeguard at a public beach assaulted the plaintiff by knocking over a chair on which he was sitting and hitting him with it, the magistrate's award of exemplary damages was overruled by the Court of Appeal on the ground that there was nothing in the evidence which suggested that the defendant pretended in any way to act under a cloak or disguise of authority. The incident was simply one of two individuals in their private capacity. Justice of Appeal Eden continued, it may well be that because of his physique and towering strength, the St. Anne Parish Council appointed the defendant appellant a lifeguard because they must have considered that a lifeguard must be gifted with a greater strength of endurance to withstand the ordeal of saving life. But that is far from saying that every act of the appellant in his employment must necessarily be clothed with authority oppressively exercised. Therefore, the strength of endurance to withstand the ordeal of saving lives, but that is far from saying that every act of the appellant in his employment must be clothed with authority oppressively exercised. I think I just said that. Anyway, therefore, the conclusion of the learned resident magistrate that the appellant's action was a gross abuse of authority was unwarranted by the evidence. It was held, however, that aggravated damages could properly be awarded since this was a case of a big man bullying a small man, but must have been a source of humiliation to the plaintiff. Okay, and that is it today for this video. Our next video is going to be on false imprisonment, so you can stay tuned for that. After we've done our video on false imprisonment, we're going to do one on the defenses to false imprisonment, and then we're going to move on to negligence. You can feel free to follow us on Instagram at Law Nerds Tutoring. If you have any questions, feel free to email us at todalaw@gmail.com. And you can always check out our website for our notes, our ebooks, and our course guides. We also have some question and answers there where we do past paper questions and give you guys the answers to them. Thanks for listening and see you in the next video. Bye.